Hi everybody. We are group 12, made up of Jessica Halfacre, Samantha Perkins, and Soraya Carter. And I am Susie Farr, and we are going to be talking about tort reform. So next slide, please. So what exactly is a tort? I was actually watching a YouTube documentary called Hot Coffee, and in the beginning of that, the presenters, I guess, the interviewers were asking just random people on the street if they knew what a tort was. And it was kind of funny because a lot of people thought they were talking about a tart. So a tort, no, it's not a tart. A tart is a pastry. So we're going to learn what a tort is. So next slide. So by definition, a tort is a wrongful act other than a breach of contract for which relief may be obtained in the form of damages or an injunction, or an action that wrongly causes harm to someone but that is dealt with within a civil court. Next slide. So there are three types of torts. An intentional tort is an act that is intentionally committed against another person with the aim of causing harm. For example, like assault, battery, fraud, fake imprisonment, trespassing. There is a knowing and intent to hurt someone, and that is an intentional tort. Another type of tort is negligence. And this occurs when a party fails to demonstrate the kind of care a prudent person would take in the same situation and an injury results from the action or inaction. Now, a negligence is the same thing as an unintentional tort. And there's also a strict liability. A strict liability is a statute, which means it's a law, and it is the legal responsibility for damages or injury, even if the person found strictly liable is not at fault. So next slide. So what do torts have to do with healthcare? So torts in healthcare are commonly known as medical malpractice or medical negligence. And malpractice is the failure by a physician to use the care and skill that other members of their profession would use under similar circumstances. See, Jessica, was this yours?
Okay, so Texas is leading the tort reform charge. They're the only state that really has a significant tort reform right now. So tort reform was first passed in 1977. It established caps on all medical damages, but this did not include expenses. In 2003, Texas passed a new aggressive reform measure, which put a cap on malpractice awards that was $250,000. The House bill that was passed has brought these changes. They required more evidence for injuries. Damages were awarded only for what was paid and or incurred. A medical report was needed to clearly define the standard of care that was supposed to be provided and then specifically how it was violated. And the most important was the award cap for all doctors involved. So it didn't do necessarily what was expected. Here's some of the changes that happened. C-section rates increased. Medicare testing expenditures increased twice as fast. There was a 0.2% increase in mortality, so that was 30,000 deaths for every 10% decreased or capped. Proportionate responsibilities rules led to mixed rewards for plaintiffs, which became kind of a big issue. Jury verdicts now had to be unanimous, and so that lowered plaintiff success. And then special circumstances were created to limit the liability for nonprofits. I'm sorry, hang on, my daughter is yelling at me. Okay, next slide. Um, So here's some of the successes that the tort reform resulted with. A 10-year look back on the reform, there was some good things that happened. The number of licensed physicians in Texas has doubled. It's been a really attractive place for doctors to go because they don't have to worry about having such high levels of liability insurance. With the money that hospitals haven't had to pay out, they've been able to expand and remodel, providing better services. The number of available specialists is rapidly increasing, and the premiums have decreased significantly by 60%. Um, so cost-based medical charity has increased, and Texas is actually the first state in 10 years to leave the AMA's states in crisis. Okay, this one was my section. This is to answer the question, why did President Obama refuse to allow tort discussions in the debates over healthcare reform back in 2009 and 2010? So the president liked medical malpractice reform, but it was all about what kind. He stated in his address to the joint congressional members in September 2009 that he wanted malpractice reform, but he would not accept tort reform. And he said, a direct quote, "I don't believe malpractice reform is a silver bullet, but I've talked to enough doctors to know that defensive medicine may be contributing to unnecessary costs." So he acknowledged where people were coming from with tort reform, but didn't think that that was really the root of the problem. And then he decided it was a good idea to continue with Secretary Sebelius leading on the initiatives that had been discussed during the Bush administration to evaluate the alternatives to tort reform. So the alternatives that were primarily focused on were state-based demonstration projects. So the states would focus on different ways that they could be reducing healthcare costs, improving quality of care and patient safety. For example, one of the ways that this was really pushed in a hospital that I work closely with is they would help their staff by tracking how long they'd gone without a patient incident, like a fall or something similar. And then there were incentives and motivations to prevent that. So that's the kind of state-based demonstration projects they were looking for. And so President Obama really wanted to focus on the quality of care and safety. He believed there were a variety of alternatives under this blanket instead of, again, the tort caps like Texas has been using. So more specific options that were more in the legal realm instead of the tort caps would be having medical experts review the malpractice suits. So you'd have a board that would review these suits before they went to an actual court. And then you would also have the possibility for the mediated arbitration. So again, instead of going to a full jury court, they would have mediation instead, which would have been a less costly and a less time-consuming process. These two ideas come from Representative Bart Gordon from Tennessee, who included this provision that would require states to use certificates of merit and other sorts of early offer programs. So ultimately, everybody's kind of at a stalemate right now with Obama's stance and then the Republican Party versus the Democrat Party. The Republicans are completely against Obamacare in its current form, largely because it didn't include tort reform. But President Obama concluded that it had to come down to philosophical issues, whether it's fair to say you can only get a certain amount of money no matter how egregious it is with regards to whatever suits came up. And I think Susie's doing this next section.
Can you still hear me?
Yes.
Okay. Okay, so these slides were Soraya's, and she did tort reform, do we really need it? Okay, answer yes and no. Tort reform refers to proposed changes in the civil justice system that aim to reduce the ability of victims to bring tort litigation or to reduce damages they can receive. That's a powerful statement that packs a big punch. But what does it really mean? In the 1980s and 1990s, tort reform was a hot topic and continues to gain traction with our judicial system. Politicians and big businesses can argue that we need tort reform to prevent lawsuits that are frivolous and end up costing the business crazy amounts of time and money. On the other hand, a judicial system without tort law or reform is more for the people and would allow additional freedoms and protections of consumer and patient rights. So recently there have been court cases in which a jury has decided on a verdict and awarded punitive damages only to be overturned by tort caps, which prevent money that the law deems in excess. So this is a balance between good and us. Currently, both sides offer valid arguments regarding tort reform, but until both sides can come up with a compromise, consumers will continue to suffer and remain at a disadvantage.